Hey guys, my name is Jim Aspel. I'm a board certified workers' compensation attorney in Farmington, Connecticut. And according to Google, one of the most common questions that somebody asks when they're looking into workers' compensation in Connecticut is, how does workers' compensation work in Connecticut? So I figured I'd do a quick video to explain a little bit of the overview. I think I and probably a lot of other workers' comp lawyers take for granted that people know what workers' compensation is and how, in fact, it works. Workers' compensation is a statutory benefit. And so what that means is that any rights and opportunities that you get in workers' compensation are a function of what the Workers' Compensation Act, the actual law, says that you're entitled to. And in Connecticut, uh, the workers' compensation law says that you're going to be entitled to a portion of your lost wages to be replaced. You're going to be entitled to your medical treatment to be covered at 100%. You're going to be entitled to a rating for a permanent partial impairment to a listed body part, and you may be entitled under certain circumstances to discretionary benefits, and under even more remote circumstances, you may be entitled to a scarring award. Um, all of that is set out in Title 31 of the Connecticut General Statutes. As far as the lost income goes, the two basic types are temporary total disability. You get that if you're totally disabled. So in other words, you can't do any work whatsoever. The second type of wage replacement benefit that you would be entitled to is called temporary partial disability benefits. And that's when you have what we call a late duty release. So in other words, your doctor says you can't do your ordinary job, but you could do something else. You can do one-handed work. You've got a 5 pound lifting restriction, whatever it happens to be. That's what we consider a late duty work restriction, late duty work restriction. And in that instance, you would be entitled to temporary partial disability benefits. Medical treatment kind of goes without saying. If you have an accepted workers' compensation case, the workers' compensation insurance company is going to pay for your medical treatment, whether that's surgery, physical therapy, prescriptions, durable medical equipment. All those things are going to be covered at 100% by the workers' compensation carrier. Permanent partial disability benefits. Generally, once you've recovered sufficiently from your injury and you've gotten as good as you're going to get, your doctor is going to put you at what's called maximum medical improvement. And at that point, the doctor is going to give you what we commonly refer to as a PPD rating. They're going to assign a percentage of disability to the body part that you injured. And depending on what that rating is and what body part you hurt, or sometimes body parts, sometimes people hurt more than one, you're going to be entitled to additional compensation for that permanent partial disability benefit. So those are the main things that you're going to be entitled to. In certain instances, after you're fully recovered, you may have some sort of loss of income or loss of earning ability, excuse me. In that case, you're going to be entitled to a discretionary benefit called 31308A. It's a benefit that the workers' comp administrative law judge may assign to you. They're going to determine what, if any, earning capacity you have with your new injury, with the limitations because of your injury, and they're going to order discretionary benefits to be paid by the workers' compensation carrier over a period of weeks. Um, in no instance are the number of weeks that the workers' compensation judge awards you going to be more than the number of weeks that you got in your permanent partial disability award. So that 31308A benefit is in fact quite limited. It's not an indefinite thing as it used to be in the past for years now. Uh, the amount of money you can get for your 308A award is going to be limited in terms of weeks to the same number of weeks you got for your permanency payments, and that rate is going to be paid at a considerably lower rate than what your lost time or your other permanency benefits were paid at. So that's that 308A award is not a large windfall of money to you. Scarring awards, by and large, they've been done away with by the Workers' Compensation Act. There are a couple of exceptions, primarily if you sustain an injury to your face or your neck. Uh, those are the primary ones. If you have a scar on any other part of your body, generally you're going to be out of luck. Um, the other language that is in the statute is if that scar prohibits you from obtaining work. So I suppose if you had a career as a hand model and you sustained an injury where you had some sort of scar or disfigurement to your hand, then perhaps you'd be entitled to a scarring award, or at least the argument could be made. But scarring awards, few and far between in workers' comp these days, but it is something that theoretically you would be entitled to. Now, uh, one thing you're not entitled to in workers' compensation is pain and suffering. A lot of people are under that misconception. No pain and suffering in workers' compensation under any circumstance. Um, you're not suing your employer, so it's not a lawsuit. It is this statutory benefit, as I say. So what you get in workers' comp is primarily a math problem. We can determine almost to the penny what your workers' compensation case is going to be worth. And if we, as your attorneys, can do it, rest assured that the lawyers for the insurance company can do it as well. They are, in fact, doing it. And they're probably trying to drive down the value of the case just as hard as we're trying to drive the value up. So those are the things you're entitled to under Connecticut workers' compensation. How it works is you actually have to avail yourself of the system. And by that, what I mean is you actually have to file a claim for workers' compensation. And I hearken back to my never-ending point that your employer is not going to file your workers' compensation claim for you. That's something you or your workers' comp attorney are going to have to do. You do that by filing a Form 30C, which is a state form. You file that certified mail with a copy to your employer and a copy to the workers' compensation office having jurisdiction over the location where you were injured. So, in fact, you need to file two 30Cs, both of them by certified mail. That's best practice. And that's something that a workers' comp lawyer is more than happy to help you with. There's no charge to file that Form 30C if we're going to represent you. It's just something that we do for our clients as a matter of course. But don't be confused if the insurance company reaches out to you and they're paying your bills and all is going well as far as you're concerned. That doesn't mean that you filed a claim for workers' compensation benefits. The carrier is administering your claim on a without prejudice basis, essentially. So they're taking care of you, but you haven't protected your rights. The only way to absolutely protect your rights is to file that Form 30C in the proper manner and to take advantage of the system. The other benefit to doing that is if you ever have a dispute, that way you have a case pending in the Workers' Compensation Commission. You can request a hearing with the workers' compensation judge and go in and say, I have this outstanding medical bill that the insurance company's not paying. I think I'm entitled to mileage. I think I'm entitled to a 31308A award. There's all sorts of things that a workers' compensation judge can adjudicate for you, but in order for him or her to do any of those things, you do need to file the claim for workers' compensation. And by filing that Form 30C, that's how you do that. So that's the sort of general overview of how workers' compensation works in Connecticut. You have to avail yourself of the system. And then, as I said out at the beginning of the video, there are certain statutory things that you're going to be entitled to, no more, no less. Um, Workers' comp is, in many, many instances, an adversarial process. So while you're claiming you're entitled to one thing, the insurance company may be claiming that you're not entitled to that thing or that you're entitled to something less than what it is you're claiming. That's why the Workers' Compensation Commission exists to adjudicate those battles. That's why workers' compensation attorneys exist to represent you in those battles. Any workers' comp lawyer in Connecticut is going to work on a contingency fee basis. It's not like an employment law case where you're paying by the hour for the attorney's services. Uh, Generally, we get paid when we get you money as a result of our efforts. So I would urge you not to let the fear of legal expense preclude you from calling a workers' comp lawyer and at least getting a consultation and figuring out what can be done. Generally, we can look at the cases online, figure out what's going on, and determine whether or not you're being treated right or not, or if we can improve your situation. So hopefully that overview helps. If you have more questions, there's a ton of information on the website, www.ctworkinjurylawyer.com. There's a number of YouTube videos that we have up on various topics through the years. If there's something specific you'd like us to answer for you, just let us know in the comments, and I'll be happy to do that. If you found the video helpful, I'd appreciate it if you gave it a thumbs up, and I'd welcome you to subscribe to the channel. We do drop content on Connecticut workers' compensation subjects with fairly good regularity. So thanks for your attention, and hopefully you found this video helpful. Okay, thanks.